Good morning. Thank you for joining us for this presentation of our speaker series, Toxicology and Societies, the Impacts of Chemicals in Our Lives. I'm Ruth Sofield, and I'm a professor of environmental toxicology and chemistry at Western Washington University. My co-host Ian Moran is a visiting assistant professor of environmental toxicology at Western Washington University. Hi, Ian. And Tracy Collier, a toxicologist who is retired from NOAA's Northwest Fisheries Science Center and continues his work as a consultant. Hi, Tracy.
Hey, Ruth.
We would like to begin by acknowledging that we at Western Washington University are on the ancestral homelands of the Coast Salish peoples who have lived in the Salish Sea Basin throughout the San Juan Islands and the North Cascades watershed from time immemorial. Please join us in expressing our deepest respect and gratitude for our Indigenous neighbors, the Lummi Nation and Nooksack tribe, for their enduring care and protection of our shared land and waterways. And now I'd like to go over a few logistics. We will save your questions for the end of the presentation, but you can use a Q&A feature on your screen at any time. You will be muted throughout the presentation, so we will use this feature to interact. The focus of our speaker series is to provide understandable examples of how events with a toxicological component have consequences to people and societies. Today, we are delighted to welcome Kirsten Groover, an associate at Beveridge and Diamond, an environmental law firm with offices around the country. Today, she will present on how chemical regulations generally operate and how their mechanisms have changed over the years. Welcome, Kirsten.
Thanks, Ruth. Okay. Can folks see this? Just making sure. I know we did a test run, but
yeah, we can see it.
Great. Thanks, Ruth.
Thank you.
So good morning, everyone. As Ruth mentioned, my name is Kirsten Groover. I am an associate attorney at Beveridge and Diamond. Beveridge and Diamond is an environmental law firm that works on a variety of matters ranging from Clean Water and Clean Air Act related issues to regulatory issues involving material restrictions, which often involve chemical regulations and how chemicals are regulated in products. And that's kind of our focus for today, just kind of going over the legal landscape relating to these chemical regulations. Only in the US, there is an entirely separate scheme that is kind of covered throughout the world, especially in the European Union. So today is our jurisdiction is the US. And in addition to regulatory frameworks that we're looking at, we'll also kind of touch base on some litigation trends that we're seeing, some lawsuits that have been filed and how those lawsuits or the nature of those lawsuits have changed over the last few years. So this is just kind of a roadmap of where we're going today. We'll talk about chemical regulations at the federal level, and then at the US state level, and then talk about litigation and some of the cases that we've seen, and then we'll finish up with a discussion of general trends. And throughout this presentation, I will talk about kind of trends that we've seen within the laws as well. So that'll be sprinkled throughout, but it'll also kind of wrap up today's discussion. So the US kind of main vehicle for regulating chemicals is the Toxic Substances Control Act, or more colloquially known as TSCA. It provides EPA authority to require a number of things, including reporting, record keeping, and testing requirements. And it also provides EPA with the authority to restrict chemicals and certain substances and their mixtures. TSCA is a very complex law, and I am not an expert on all aspects of it by any means, but there are just a number of different sections within TSCA that kind of lay out the different areas of authority for the EPA, and I'll just kind of highlight those here. One of those is to require what's called a pre-manufacture notice for new chemical substances before manufacturing occurs. There's also a requirement within TSCA or authority provided within TSCA to require testing of chemicals by manufacturers, importers, and processors where there are risks of exposure or risks or exposures of concern are found. There is also the authority within TSCA for EPA to issue what's called significant new use rules. And they do this when EPA identifies a significant new use that could result in exposure to or releases of a substance of concern. The statute also provides authority for and directs EPA, the Environmental Protection Agency, to maintain what's known as the TSCA inventory. And this inventory contains more than 83,000 chemicals at present. And as new chemicals are commercially manufactured or imported, they are placed on this list. TSCA also provides authority to require individuals who are importing or exporting chemicals to comply with certification, reporting, and or other requirements. And the last kind of bucket that falls within this kind of space is that TSCA provides authority to require reporting and record keeping by people who manufacture, import, process, and or distribute chemical substances in commerce. So those are the kind of different areas of authority that EPA is granted or can exercise under TSCA. I'll just go over two of those that I've mentioned a little bit more in depth. The first is the TSCA inventory. So Section 8B of TSCA requires EPA to compile, keep current, and publish a list of each chemical substance that is manufactured or processed, including imports, in the United States for uses under TSCA. As I mentioned, this is called TSCA, the TSCA inventory, or it's also just referred to as the inventory if you're talking amongst people who are talking about TSCA. Maybe that's not a frequent subject of conversation for a lot of folks. But the TSCA inventory contains all existing chemical substances manufactured, processed, or imported that do not qualify for an exemption or an exclusion under TSCA. I won't get into the exemptions or exclusions, but they do exist under the statute. As I mentioned, TSCA prohibits the manufacture or importation of chemicals that are not on the TSCA inventory or that are not already subject to an exemption. So any chemical substance that is not on the TSCA inventory is classified as a new chemical substance. But a chemical substance that is already listed on the TSCA inventory is classified as an existing chemical substance. Those have different implications within the statute. That's just one kind of component of the TSCA inventory. In addition to defining whether a specific substance is new or existing, the inventory also contains flags for those existing chemical substances that are subject to manufacturing or use restrictions. There's also a designation in the inventory as to which chemicals are confidential or which chemicals are public. There are also kind of active and inactive sections. It's an interactive inventory, and so there are just a lot of pieces that allow for different users and EPA to kind of look at and identify kind of what they're looking at when it comes to a particular chemical that's at least regulated by TSCA. Section 5 of TSCA outlines how substances are added to the inventory. Again, I won't get into the process of how they're added, but there is a process for it, and it has resulted in the addition of many chemicals. Originally, the inventory consisted of about 55,000 chemicals, and it now has over 85,000 chemicals on the list and is likely growing. Another component of TSCA that I mentioned at the beginning is the significant new use rules. They're also referred to as SNURs. I think both are kind of a mouthful. So I'll probably just stick to significant new use rules. But These can be used to require notice to EPA before chemical substances and mixtures are used in new ways that might create concerns. More specifically, under Section 5A of TSCA, EPA can determine that a use of a chemical substance is a significant new use, and EPA must make this determination by rule. So that means they have to go through kind of a formal rulemaking process after considering all relevant factors. And some of these factors include the projected volume of manufacturing and processing of a chemical substance, the extent to which a use changes the type or form of exposure to humans or the environment when exposed to that chemical substance, the extent to which a use increases the magnitude and duration of exposure of humans or the environment to a chemical substance, and the reasonably anticipated manner and methods of manufacturing, processing, distribution and commerce, and disposal of a chemical substance. Once EPA determines that a use of a chemical substance is a significant new use, TSCA Section 5A requires a person to submit a significant new use notice to the EPA at least 90 days before they manufacture, and under the statute, manufacture includes importing or processing the chemical substance for that use. So those are just two components or pieces of TSCA. And as I said, TSCA is kind of the main vehicle that is used within the United States at a federal level to regulate chemicals. And the EPA has made changes to different portions of the rules that are implementing TSCA. And so there are new requirements and new interpretations that both manufacturers and the general public can keep track of in order to kind of track compliance or track latest obligations. So I'll move on to the state level. One thing I'll note, like, states are their own entities in the sense that there are kind of federal preemption type considerations that need to be thought about, but generally states pass their own legislation in addition to those that are already enacted at the federal level relating to chemicals and or material restrictions. States have recently passed a slew of new laws that contain both restrictions and reporting requirements, or sometimes one or the other. Previously, states really just focused on consumer uses. And however, over the time, they've expanded to covering kind of commercial and industrial controls of the uses of chemicals. Washington State and California are the current leaders, I guess some would say, with regards to the most aggressive legislative frameworks for chemicals. But that's not to say that even smaller states or just other states don't have their own regulations and laws that they're passing with regards to specific substances. As we'll see later, and I'll discuss both California and Washington, their frameworks are just very broad, whereas I think if you look at other states, you'll see that they're a little more targeted, maybe targeting a specific chemical rather than a class of chemicals, for example. And that's a kind of another trend we've seen. States that are passing newer laws or that are kind of getting into passing laws regulating chemicals, they're starting to regulate on a broader level by class. And so that means they'll pass a law and an implementing regulation that covers all of flame retardants rather than just a specific one, or all of PFOS instead of just PFOA. So that's kind of one of the trends that we've seen with regards to legislation at the state level. So the first state framework that I wanted to talk about is Washington. It seems it would do a disservice to not discuss Washington as a resident of Washington and presenting for Western Washington University. So As I mentioned, Washington is one of the leading states in terms of chemical regulations, and it's a very aggressive framework that they've kind of that they've passed as law. In 2019, Washington enacted what's called the Pollution Prevention for Healthy People and Puget Sound Act. The act directs the Washington State Department of Ecology to implement a program to reduce priority chemicals in consumer products. And so on a 5-year cycle, the Department of Ecology is empowered to take regulatory action to reduce the use of identified priority chemicals in those identified priority products or packaging. Ecology's implementation program is called the Safer Products for Washington, and that's how I'll refer to it kind of moving forward. So this implementation program has 4 distinct phases. The first one is to identify priority chemical classes. And if a chemical class is not already listed, or if ecology decides to regulate a specific chemical, they can do that too. So it's chemicals or chemical classes. The second step is to identify priority products that are significant sources or uses of those chemicals. The third step is to determine if safer alternatives are available and feasible, and decide what to do with the chemicals and in the priority products that they've identified. Ecology can make a determination that the chemicals in those types of products should be restricted, or that they should be subject, those manufacturing that product or that substance should be subject to a reporting requirement, or they can make a determination of no action. And then the final step is a formal rulemaking to implement the determinations that they came to in step 3. And I will note that each of these steps is dictated in the statute with like a specific time frame. So if you look at the statute, it'll say, at least like for this first cycle that ecology completed earlier, I think it was last year, that ecology has to finish step 1 by June 2030, and then they have to finish step 2 by June 2031, just as an example. So it's all very structured. It's a very structured process, and the program itself and the law incorporated a lot of opportunity for stakeholder input, both from manufacturers, industry, as well as nonprofits, general public, and society. And at least what we saw through that first cycle, stakeholders really did take advantage of those opportunities to interact with the agency and the individuals who are driving the program. And we did see considerations taken by ecology from the comments and the meetings and webinars that ecology hosted. So I'll go into each of these steps a little bit more in detail. As I mentioned, the first step in the process is to identify priority chemicals or classes of chemicals. And when ecology identifies priority chemicals, they have to show that the chemicals identified meet at least one of 3 criteria. The first criteria is that the chemical or a member of a class of chemicals are identified by ecology as a high priority chemical of concern as defined under existing law, or a persistent bioaccumulative toxin under already existing law. The second criteria is that the chemical or members of a class of chemicals are regulated in consumer products under specific existing laws, or as a hazardous substance under specific existing laws. And then the third criteria that it should meet, or at least one of these 3 criteria, is that the ecology has to determine that the chemical or members of a class of the chemical are a concern for sensitive populations and sensitive species. And to make that determination, they also include a number of or consider a number of factors, such as the potential for the chemical or class of chemicals to contribute to or cause adverse health or environmental impacts. Within the first cycle, when the Washington State Legislature passed the statute, they identified the first set of priority chemicals. So it's not until the second cycle, which starts 5 years after after the first cycle, that ecology went through the process of identifying priority chemicals. And if you're curious, you can go on to the Washington State Department of Ecology's website and look at their Safer Products for Washington implementing program, and it has both the chemicals that they identified for the second cycle as well as everything that they kind of went through for the first cycle. So for each of these steps, I'll go through kind of the substance of the step, and then I'll kind of pair it with what ecology did in that first cycle, just because ecology already completed the first cycle, so it's easy. It's nice to use as an example. Now, the chemicals that were used in the first cycle, as I said, were pre-identified for the Department of Ecology, but you can see here that there were 5 different classes of chemicals that ecology decided, or excuse me, that were identified in the statute. And it included PFAS, phthalates, flame retardants, PCBs, and phenolic compounds. So moving on to the next step within ecology's Safer Products program, during this phase, ecology has to identify priority consumer products that are a significant source of or use of priority chemicals. And when I say priority chemicals, I mean those that were already identified in step 1. When ecology determines priority consumer products, it has to consider at least 7 different criteria. The first criteria, and they're all listed here just so that for ease as well, but the first one is ecology has to consider the estimated volume of a priority chemical or priority chemicals added to, used in, or present in the consumer product. Ecology has to consider the estimated volume or number of units of the consumer product that are sold or present in Washington. Ecology also has to consider the potential for exposure to priority chemicals by sensitive populations or sensitive species when the consumer product is used, disposed of, or has decomposed. And that's an interesting, I think, not, I guess, qualifier, because I think a lot of chemical regulations sometimes focus on exposure when a product is used. And at least during the initial kind of stakeholder process for cycle 1, there was a lot of discussion of just measuring and data around how you identify volumes for chemicals in products that have been disposed, just kind of as an aside. Ecology also has to consider the potential for priority chemicals to be found in the outdoor environment with certain priorities given to certain things. They also have to consider whether or not another state or even nation has identified or taken regulatory action to restrict or otherwise regulate the priority chemical. And then they also must consider the availability and feasibility of safer alternatives. And then finally, they have to consider whether ecology has identified the consumer product in a chemical action plan completed under Washington's Hazardous Waste Management Act as a source of a priority chemical or other reports or information gathered under other relevant regulations. One thing I'll note with regards to these 7 criteria, ecology is not required by law to give them equal weight. So when considering which priority products that have the priority chemicals in them to regulate, ecology can consider and place emphasis on different criteria in its evaluation process. One of the other things I wanted to note for this step is that the law requires ecology to notify the public of the selection of the priority products, including any identified peer-reviewed science and other sources of information that the department relied on for the basis of its selection. And then it also has to kind of draft a schedule for how it thinks it will determine or make a determination with regards to these products and chemicals. And so I just say that as an example of how the law kind of put in opportunities and required stakeholder involvement throughout this process. So this second step in the first cycle, you can see here the different products that Ecology identified as priority consumer products that contained the priority chemical that the law identified. And I think what's interesting to note here is that when you think about a regulation that says, oh, we are regulating PFAS or we're regulating all phthalates, that's significantly broad, and that can have implications for a lot of people, both manufacturers as well as consumers of products, because that can just for a variety of reasons. And so having specific consumer products that are a limiting factor, I guess you could say. And so when you think about phthalates and you think about what's regulated, it would only be phthalates in vinyl flooring or personal care products. So step 3 is where Ecology has to decide what it's going to do with the priority chemicals in those priority consumer products that it identified. And Ecology can make kind of 3 different choices. They can decide that no regulatory action is actually needed at this point. They can decide whether or not they should require a manufacturer to provide notice of the use of a priority chemical or a class of a priority chemicals or class of priority chemicals. And they can also decide, or they will decide whether or not to restrict or prohibit the priority chemical or class of priority chemicals. Ecology may only restrict or prohibit a priority chemical or members of a class of a priority chemical in that consumer product if it determines that safer and alternatives are feasible and available, and that the restriction will reduce a significant source of or use of the priority chemical, or that the restriction is necessary to protect the health of sensitive species or populations. And so those are kind of the guideposts that Ecology has to consider when making that kind of most most onerous determination, which would be a restriction. So during the first cycle, Ecology decided to restrict some priority chemicals in certain products and then impose the reporting or notice requirement on certain products. It varied, and there was a comment period after Ecology made the determination. And then but it's not until we get into this next step, that fourth step, that Ecology actually formally adopts the implementing rule that says, okay, this restriction is in place or this notice requirement is in place. So as I kind of alluded to, this is the step where everything is formalized. When Ecology proposes and adopts a rule, it is required to consider and address input received from the stakeholder process. And so this is where we see all those opportunities for engagement kind of coming to a head with the actual writing of the law, or excuse me, of the rule in this case. Ecology must also identify expected costs and benefits of the proposed rules to both the state agencies that are administering and enforcing the rule, as well as the private businesses or people who are going to be affected by the rule. One thing to note here that is interesting, the law requires that if Ecology adopts a rule implementing a restriction on a priority chemical, that restriction won't take effect until 365 days or a year after Ecology formally adopts the rule. So there's kind of a year of a grace period, if you will, in terms of when that rule takes effect. And within the rules, they themselves also often have grace periods. So just because, let's say it's a year later and there's a restriction in place, it doesn't necessarily mean that that restriction is effective that day. If you look at the language of the rule, it'll sometimes say no PFAS, for example, in X product by January 2030 or something like that. So there are timelines for each of the different chemicals in the products identified. So in the first cycle, when ecology went through the rulemaking, ecology adopted rules that impose both reporting requirements or notice requirements and chemical restrictions. And this rulemaking process is the culmination of that cycle one. And so as soon as ecology finishes cycle one, it's already starting cycle two, and it'll go back into that step one and it'll start everything over again. And as I noted at the beginning, this is kind of a 5-year iterative process. And so every 5 years, we can expect to see new priority chemicals and new priority consumer products that contain those priority chemicals that ecology is focusing on. But in terms of the rules that ecology implemented and adopted during that first cycle, you'll see kind of different on the slides how ecology kind of divided things up. And so there were restrictions now by rule on bisphenols in drink cans and thermal paper. There are also restrictions on organohalogen flame retardants in electronic and electric products with plastic external enclosures intended for indoor use. And so again, they're not necessarily always a wholesale restriction. Each of the rules have specific kind of thresholds, and you can go to the rules if you're curious or interested to see what exactly the restriction language is and what maybe the notice requirement is for this particular chemical in that particular priority consumer product. So that's Washington's program. The other kind of chemical regulatory framework that I wanted to discuss at the state level is California's Safe Drinking Water and Toxic Enforcement Act. It's more colloquially known as Prop 65. Some of you may be familiar with the phrase Prop 65 because you see it at the warning as a warning when you're online shopping for a product, whether that's furniture or ski goggles or what have you. It is somewhat ubiquitous. So California's Prop 65, as I said, is officially known as the Safe Drinking Water and Toxic Enforcement Act. And it was a ballot initiative that was voted into state law over 3 decades ago. So it is arguably kind of it has been in place much longer than Washington's program and it is designed to protect the state's drinking water sources from being contaminated with chemicals known to cause cancer, birth defects, or other reproductive harm. It also imposes a warning requirement on businesses that in which they are required to warn Californians about exposures to those types of chemicals in products, in workplaces, or that are released to the environment. So when you think about kind of who would be covered by Prop 65, it's generally businesses with 10 or more employees, businesses who are selling products in California or located in California, and businesses that cannot demonstrate exposure below safe harbor levels. These are all the entities that are subject to kind of Prop 65. So if you think about it, a business with 10 or more employees, that can be small. And so it can have a broad reach. With regards to, I guess one other thing, like this also means that even if a company is based in another state or a foreign country, but it is selling to California customers online or through national retailers, that company would also be expected to comply with Prop 65. So that's something that kind of goes back to that comment I made about maybe you've seen the warning online. And even if you're shopping at a retailer that isn't located in California. But because they can reach Californians, it's something that they have to be aware of. So businesses have to provide warnings about significant exposures to chemicals that cause cancer, birth defects, or reproductive harm. There are safe harbors, and the safe harbor levels that are the levels of exposure to a listed chemical that don't require a warning. And each chemical has its own safe harbor, and that I won't get into that, but it's basically something that says, okay, if you know your product doesn't meet this threshold, then you don't have to provide the warning, at least to consumers. Similar to TSCA, Prop 65 also requires the state to publish a list of chemicals that are known to the state to have those kind of health impacts to consumers or the environment. And the list is updated at least once a year, and it currently contains about or over 900 chemicals. It is also growing. And so it's another thing that if you are a business or if you're a manufacturer, it's something that I would imagine that they're constantly watching to see if this is something that they would become in scope of if they weren't already. So I mentioned the warning requirements. Businesses are required to provide what's called clear and reasonable warnings before they knowingly and intentionally expose anyone to a listed chemical. This warning can be given in a variety of ways, including labeling a consumer product, posting signs at a workplace, distributing notices at a rental complex, or publishing notices in a newspaper. It's all about clear and reasonable warnings, and that's kind of a term of art just within kind of the legal world. Additionally, the implementing regulations require that websites that sell products that qualify for the warning have to include those labels. And once a chemical is listed on that Prop 65 list of chemicals, businesses will have a year or 12 months to comply with those warning requirements. There are penalties. Businesses that fail to provide notices can be penalized up to $2,500 per violation per a day. And the law also allows for both government enforcement by the California Attorney General's office and other attorneys, as well as private enforcement by individuals acting in the public interest. And you'll see when we talk about some of the litigation that has been happening that consumers do bring Prop 65 violation cases. And so that kind of wraps up state frameworks. I'll move on to just talking or looking at this more through like a chemical or class of chemical lens. So PFAS is a group of human-made chemicals that's not naturally found in the environment, and they have emerged in the last decade as an issue of increasing interest to state legislatures and the federal government. They have often been referred to as forever chemicals because they are stable and they are persistent in the environment and the human body. States are using a multi-pronged approach to manage PFAS, and this includes reducing or eliminating their use in common source material, setting testing and reporting limits, and directing and financing remediation of any potential PFAS contamination or at sites. At a federal level, the EPA has also taken steps to regulate PFAS. This includes things like implementing a national drinking water standard for PFAS, and it recently finalized a rule to designate two widely used PFAS, PFOA and PFOS, as hazardous substances under the Comprehensive Environmental Response, Compensation, and Liability Act. That's more known as Superfund if you think of large contaminated sites. Some are one of which is Portland Harbor. Another one is like the Duwamish in Seattle. That's kind of, so if you're thinking about PFAS as a hazardous substance under that law, it means that or it provides for remediation under that law of those substances. The varying approaches, at least especially at the state level, can create difficulties for a variety of folks. That, for example, different regulations can define PFAS differently. It can limit or expand the scope depending on the jurisdiction. Regulators that seek to manage PFAS as a class can make it difficult to identify and report on PFAS in products. Do you report on PFAS as a class, or do you report on the specific chemicals within your products? There's just a lack of clarity there. And then the different regulatory approaches also mean that it's hard to find a streamlined way to compliance. And so finding that one size fits all approach can be hard and sometimes not feasible. And that means just targeting your compliance approach for each jurisdiction that you operate in or sell within. So at the federal level, I mentioned a couple of things. One of the other recent regulatory developments relating to PFAS is the TSCA reporting rule for manufacturers. And again, this includes importers of PFAS. They have to report a whole host of information. I'll just run through a few of the things that they have to report. One kind of subject is chemical specific information. Companies have to identify the PFAS that they manufacture. And sometimes they can provide generic names. Other times they need more description. Another topic for reporting is the manufactured amounts. So for each calendar year from 2011 to 2022, and for each PFAS reported, companies have to provide certain production volume data. They also have to report environmental and health effects. For example, they would need to provide all information concerning the environmental and health effects of each reported PFAS in its possession or control. They would also be required to report under the rule worker exposure data, so information regarding the number of individuals exposed to PFAS in their workplaces of employment and the duration of that exposure. I'll note that this is a one-time reporting requirement, and it only requires reporting of information that is known to be or reasonably ascertainable by the submitter. So this is kind of a counterbalance to the amount of information that the rule requires companies to report with what is, I think, some would say a more reasoned approach to having that information. And the fact that it's only once means that companies who are subject to the reporting rule only have to go through and gather all of this data once. I'll also note that this rule applies to products that contain PFAS in any amount. So it is broad in that sense. It's certainly an interesting rule, and we'll see kind of what happens with regards to the disclosures made or the reporting made. At the state level, Maine has enacted a PFAS law that imposes both a reporting and a material restriction. It generally prohibits the sale of products containing intentionally added PFAS as of January 1st, 2032. And this prohibition applies to products sold in Maine that contain in-scope PFAS. So that's kind of just a nod to the fact that in-scope PFAS is defined a specific way in Maine. In any amount. And reporting obligations would also not apply until 2032 as well. It also only applies to products that contain intentionally added PFAS. And so that's another thing that states have used to kind of distinguish between PFAS as a byproduct of manufacturing versus PFAS that is intentionally added for a purpose into a product. Now, Maine is not the only one. There are a handful of other states that are considering or have enacted PFAS-related laws. The restrictions that these laws impose apply to different product categories, and this means that there's just kind of a patchwork of compliance. So it's important to know what product is subject to what restrictions or what reporting requirements in each jurisdiction that you're operating in or that companies are operating in. Despite the differences that we see, I think generally, at least my colleagues who are experts in this area, they expect that many states will eventually follow in Maine's footsteps. Some examples of states with proposed laws that impose a reporting obligation, just kind of so you get a flavor, are Colorado, New Hampshire, New York, Vermont, and Minnesota. Other states that are considering imposing consumer product labeling requirements include Vermont, New Hampshire, and Michigan. I would have to double check on the status, but they might have enacted laws that require consumer product labeling. And then there are also a handful of states that are considering restrictions of chemicals. And so New Hampshire is another one. With the intent to restrict all products containing PFAS by 2030. New York has a proposal to restrict PFAS in all product packaging. And then Vermont also has product restrictions that are to be defined by implementing rule. So that kind of wraps up just that gives you a sense of how different states and different jurisdictions, both federally and state, are tackling a single chemical class. And even there, it's just different, like different timelines, different restrictions, different requirements, one-time reporting requirements, annual reporting requirements. And so you kind of get a sense of how, I don't want to say chaotic, but how different the landscape can be depending on where you are. So this last kind of portion of the presentation, I'll just kind of go over what we've seen with regards to litigation and stakeholder trends. With regards to PFAS, there have been a handful of different types of claims that plaintiffs have brought over the years. Typically, we've seen, or at least at the beginning, we saw claims that really focused on direct liability. And those include things like plaintiffs filing complaints against a paper goods manufacturer, arguing that their manufacturing operations contaminated their soil and drinking water with PFAS chemicals. Another kind of bucket of claims that have served as lawsuits for PFAS focus on indirect liability. And one example of this is market share liability, which is a legal doctrine in products liability law that allows plaintiffs to bring a case against a group of product manufacturers for an injury caused by a product, even when the plaintiff does not know where the product originated from. And so we've seen plaintiffs file lawsuits against PFAS manufacturers, even though they don't necessarily know which manufacturer is responsible for the PFAS in a particular product. We also see, at least with PFAS lawsuits, companies facing claims from a variety of stakeholders, whether it's states, cities, nonprofits, citizen suits that are then merged into class actions. Where I think plaintiffs originally focused on manufacturers, we're now seeing them pivot and expand to focusing on just companies more broadly, like food retailers or packaging, and so things like that. I'll just briefly mention a couple of cases that have been in the news. The first is Dickens versus Thinx. For those of you that don't know, Thinx is a period underwear company. And in 2020, 3 different lawsuits were filed against Thinx, and they were eventually consolidated into a single class action lawsuit. The class action alleged that Thinx misled consumers by marketing itself as an organic, sustainable, and non-toxic alternative to traditional single-use menstrual products like tampons or pads. The plaintiffs in the class action argued that despite this marketing message, Thinx used PFAS chemicals to enhance the performance of their underwear, including but not limited to its moisture wicking and leak resisting qualities. Notably, in their complaint, the plaintiffs included evidence that they had from third-party testers of PFAS and other toxins in the underwear. And so that's in a lot of the cases we've seen, the cases present third-party testing, and I think that that's been an interesting development with regards to this litigation generally. Another thing I'll note here is that they focused on misleading consumers from a marketing perspective. So that's kind of like consumer, like consumer awareness. And that's kind of one area of law. If they were to talk about like personal injury or harm, that would fall under a different doctrine of law. And it's interesting that here they focused on the misleading marketing and they didn't necessarily go into injury that could result from potential exposure to the PFAS that they argued was in the underwear. This suit did come to resolution. Thinks agreed to a settlement in which they would pay $5 million to reimburse individuals who had purchased Think's underwear during a specific date range. And they also agreed to take a number of other steps, including changing its marketing and production processes, as well as taking steps to ensure that PFAS was no longer intentionally added to their products. Another case that we've seen is another class action as well. This one filed, against McDonald's Corporation regarding PFAS in their food packaging. Plaintiffs argued again that, or again being like the focus here is on marketing and messaging, that McDonald's repeatedly said and communicated to consumers that food safety is at the core of its processes and procedures, and plaintiffs said that this was misleading because their food packaging contained PFAS. And in their complaint, the plaintiffs noted that foods with higher levels of sodium and fat, like fast food, have stronger likelihoods of PFAS migrating from the food product packaging into the food. Again, here, plaintiffs provided third-party testing that found PFAS, and I think they tested a Big Mac, some chicken McNuggets, cookies, and French fries, all of which were independently tested and found to contain PFAS. Um, Ultimately, plaintiffs argued that McDonald's knew for a while that its food packaging contained PFAS and that they intentionally chose to use PFAS within its packaging, but they just failed to warn the customer. This case is still ongoing. I don't know if it will settle. I don't know if it will go to trial. We'll see. But that's just kind of another example of another way in which stakeholders are kind of bringing suit for chemicals in products. This last kind of case example is just it's not a lawsuit yet. The Center for Environmental Health, which is a nonprofit in California, they announced their intention to sue a handful of athletic or activewear brands, arguing that they violated California's Prop 65 law by failing to warn consumers that their products contained bisphenol A. Again, we see testing coming up. The CEH tested clothing from a variety of these brands in a variety of their products, and they allegedly found BPA in clothing at levels that were higher than the allowable limit. The nonprofit sent legal notice after conducting this testing, but from what I've seen, I think they're more into, or their kind of processes are more into working with companies to kind of remove the chemical from the product rather than pursuing litigation if they can get a resolution outside of litigation. But we'll see whether or not they end up filing suit. So I'll wrap up with just kind of summarizing what I've kind of sprinkled throughout our presentation today with regards to some of the trends and changes that we've seen throughout this regulatory landscape. From a legislative perspective, states are expanding the chemicals of concern that are being regulated. So where laws initially focused on chemicals like a specific flame retardant, they are now moving on to classes of chemicals. That means they're looking at all of PFAS, BPA, PCBs, and others. And because each state has their own legislative and regulatory frameworks, as you saw, it means that there are just a ton of different requirements that either align or are slightly aligned or slightly misaligned. Regulators have also shifted in thinking about the frameworks that they use to regulate the chemicals themselves. So where initial frameworks used to be risk-based, they're now kind of thinking, or at least considering, a more hazard-based regulatory regime. A hazard-based approach is something that looks at if a substance possesses certain hazardous characteristics, then it's too dangerous and it's effectively banned. A risk-based approach, just high level, is that my understanding is that a chemical can still be banned, but only if all measures and steps to prevent exposure have been considered and evaluated and shown to be inadequate. I mentioned the regulation of chemicals as a class and not individually. And then I think just I'll end by noting the expansion of lawsuits that we've seen. Again, it's really just grown in volume. If you were to Google on any given day how many lawsuits have been filed that relate to PFAS, I would imagine it changes weekly. And we're also just seeing a lot of lawsuits just more generally against retailers and not specifically about manufacturers. And I know we are very close to time. So with that, I will stop talking.
Thank you, Kirsten. We have some really good questions. We only have maybe time for one or two at this point. And I think I want to go back to one about Prop 65. And there's a question from the audience member, and then there's also some discussion that me and my co-hosts have been having. And that's related to how pervasive those warnings are about the chemicals that can be carcinogens or reproductive toxicants, for example. And so the question from the audience member is, what do you think about those, the efficacy of it? It seems like because those warning signs are everywhere, people are desensitized to them. And so I'm just wondering that, plus we've also heard that what happens in California drives markets. And so like if you could kind of just quickly, like, what are your thoughts on how effective Prop 65 is?
Yeah, I think it's interesting that it's a great question. I actually just read an article that was debating kind of the efficacy of it. And I think it's effective in that it does, like when someone sees a warning, they think, well, shoot, what is this? And I think it also can have kind of reputational impact for the manufacturer or company that has to provide the warning, in the sense that it informs customers as to something that is potentially harmful to them in their product. And so I think that it's hard to opine definitively on whether or not it's as effective as it was when it first started, just because the warning has become so prolific. But I think that it still does at least put folks on notice, especially if they don't know what Prop 65 is or what it is required to do. And then with regards to the second component of your question, I think it was about California being a leader. That's right. We've seen California take the lead in the chemical space, and then in other spaces as well. And I think that it will continue to be a driver for a lot of things. And so I think watching California is always a good thing to do.
Yeah, and then other states that you would call out, you pointed to, I guess, Washington and Maine with examples, but would you also, like if you were to say the states in the US that are really kind of at the forefront of considering chemical regulations, which would you like, kind of which ones do you see?
I think Vermont is another one that I've seen come out with new regulatory frameworks. Minnesota also has a PFAS regulation that I know is very much talked about. Those are the other two that really come to mind. But I know that the other states that I think of are just like chemical specific. They're not holistic frameworks like California's and Washington's.
Right. Well, thank you so much, Kirsten. Thanks to everybody who's on here. This is our last presentation of the academic year. And I just want to thank everybody and hope you enjoyed the summer. Thank you so much. Bye, Kirsten.
Thank you.